The reason for the summary chain of title is to guarantee that you have a rightful claim upon the land patent and its contents, as it is a contract from the United States of America and the first grantee or his heirs or the assigns forever. And forever isn't up yet. This patent is a private contract between the United States of America and the first grantee or his heirs or assigns. If you bought the property, you are an assign. And in the United States Constitution it says in Article 1, Section 10, Clause 1, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin at tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. So, no state shall make a law impairing the obligation of contracts. Let me say that again. No state shall make a law impairing the obligation of contracts. The contract clause provides that no state may pass a law impairing the obligation of contracts, and a law in this context may be a statute, constitutional provision, municipal ordinance, or administrative regulation having the force and operation of a statute, but are judicial decisions within the clause. The abstract principle of the separation of powers, at least until recently, forbade the idea that the courts make law, and the word pass in the above clause seemed to confine it to the formal and acknowledged methods of exercise of the law-making function. Accordingly, the court has frequently said that the clause does not cover judicial decisions, however erroneous, or whatever their effect on existing contract rights. So, what did we learn? The limits on the states may not impair the obligation of contracts. Article 1, Section 10, Clause 1. Also, we are doing the chain of title to show that you do not have a break in your chain of title as shown in this image. A break in the chain could exist for many reasons, like a buyer bought a piece of property from the seller on a contract for deed. Then when the contract is paid off, the seller forgot to issue a deed for final conveyance of the legal title as the contract stated. As I said, there are many other reasons as well, but we won't get into them reasons here now. So, a connected chain of title needs to be connected all the way around, from the patent, here on the left, then around, back to your deed, and then you finally can do the acceptance of declaration of the land patent. Before this act, you are not fully connected as shown here. So, when you finally do the acceptance of declaration of land patent, you are fully vested in all rights, title, and interest, shown with this golden link here, binding you to that patent. It is important to note that you should read and know exactly what the actual patent says, as each is different to some extent.